The Executive Overreach Task Force will come to order, and without objection, the chair is authorized to declare recess of the committee at any time. I'd start with my opening statement. I want to thank Chairman Goodlatte for supporting the Special House Judiciary Committee Task Force on Executive Overreach, which will examine the problem of Congress's gradual ceding of legislative power to other parts of the federal government and the President's taking additional legislative powers even beyond that. This is much more than a mundane process problem. It's a tragic result for individual rights and liberties. Policies imposed by federal agencies are crafted by unelected bureaucrats because those bureaucrats don't have to answer to the American citizens over the course of regular elections. They have little understanding of the desires and concerns of those Americans. And so they produce policies that, for example, make energy more expensive, take people's property through federal regulations, drive down wages through lawless amnesty programs, and restrict communications on the internet. The founders insisted on keeping policymaking in the hands of regularly elected congressional representatives precisely to avoid these sorts of policy catastrophes. As the former historian of the House of Representatives, Robert V. Rimini, has written, the framers of the Constitution were absolutely committed to the belief that a representative body accountable to its constituents was the surest means of protecting liberty and individual rights. So anxious were they to affirm legislative supremacy in the new government that they failed to flesh out the executive and judicial departments in the Constitution, leaving the task to Congress and thereby assuring that the legislature would retain control of the structure and authority of both those branches of government. And within that system of legislative supremacy, the House of Representatives was to serve a unique role. Alone among all federal institutions, the House has consisted solely of those duly elected by the people. Further, the Constitution grants the House the exclusive power to originate all legislation for raising revenue. The House of Representatives is the most regularly elected body in the federal government. In Federalist 39, James Madison wrote, the House of Representatives is elected immediately by the great body of the people. As such, the House of Representatives will derive its powers from the people of America. In Federalist 52, Madison elaborated, as it is essential to liberty that the government in general should have a common interest with the people, so it is particularly essential that the House should have an immediate dependence on and an intimate sympathy with the people. Frequent elections are unquestionably the only policy by which this dependence and sympathy can be effectually secured. That's James Madison. In this age of hyperpartisanship, when more and more attention is paid to political results and less to constitutional means, we tend to lose sight of why the founders created the system that they did. Focus not on results, but on process and a separation of powers. Under that system of a separation of powers, each branch of the federal government was expected to protect its own constitutional powers such that no single branch accrued power it wasn't allocated by the Constitution. The founders understood that individuals were free in direct proportion to each branch of the federal government staying strictly within its own bounds, and the most important lane was the legislative lane, a narrow road of strictly enumerated powers ridden by a Congress consisted of duly elected representatives, with the House of Representatives, the body most regularly elected, and with special powers over the origination of revenue bills, in the driver's seat. But today, many legislative and budget powers have been ceded to presidents and the executive branch through statutes, delegating legislative responsibility to federal regulatory agencies composed of unelected people, and statutes mandating automatic and increased spending on certain programs administered by the executive branch. Other legislative powers have simply been seized by presidents who exercise sheer will to trump the rule of law. Whatever the means of the loss of legislative power by Congress, it's imperative that Congress reclaim it, not simply for its own sake, but because without it, individual rights and liberties cannot flourish as the founders intended. It's long been my view that the framers of our Constitution structured the three branches of government in a fashion that, with as bright a lines as they could draw between each three branches of government, understanding, though, that language could not precisely define the distinctions between the Article I, Article II, and Article III authorities within the Constitution. But they did rely on human nature, and they believed that each branch of government would jealously protect the powers granted to it in the Constitution, and there would be a static tension that would be achieved between the three branches of government. I believe that has shifted over the years, and we're here to address this in this task force. And again, I thank Chairman Goodlatte for organizing this task force, and I would recognize the ranking member, Mr. Cohen, for his opening statement.
Thank you, Mr. King. I'm pleased to be serving as the ranking member of this committee, the Executive Overreach Task Force. I appreciate serving with Mr. Conyers and fellow members of this committee and being the chair. Mr. King and I share a lot of things in common. That's true. We both have the first name Steve. Neither one of us endorsed Donald Trump. But we believe in the Constitution, we want to have good government, and we care about government, and we will work together on this committee. The Constitution makes clear that all legislative power is vested, quote unquote, in the Congress. Article 1. Some of our witnesses today take the view that this vesting of legislative power means that Congress cannot constitutionally delegate power to executive branch agencies, even when it retains ultimate authority to determine when and how much power should be delegated. They asked us to look only at what they defined to be the founding generation's view of government and the separation of powers, and asked us to reach that same conclusion, telling us that much of the intervening 200-plus years is not of any real importance in understanding how our Constitution should work. Perhaps unsurprisingly, they suggest that the Constitution, as they claim it was understood by the framers, may require Congress to cut funding for Social Security, Medicare, and Medicaid. Maybe coincidentally, they argue that the reading of the Constitution raises questions about the constitutionality of the Affordable Care Act, which has thus far provided 18 million Americans with health insurance, ended discrimination by insurers against those with pre-existing conditions, and allowed 2.3 million young adults under 26 to remain on their parents' health insurance, among other benefits. Indeed, some of our witnesses contend that Congress went astray when it began to delegate authority to the executive branch to enforce regulations on Wall Street, protect public health and the environment, ensure workers' rights, and guarantee civil rights. It is not too much of a stretch to say that some of our witnesses would like to extend much of the 20th and 21st century, would like to see much of that repealed. My guess is that they probably lack the votes to achieve such an end through the political process, so instead they just turn to a constitutional theory that says we should only look at one snapshot of our history and ignore all the rest. Why is that we have agencies that develop regulations? As the Supreme Court has recognized, Congress's delegation of authority to the executive arises from the practical recognition that our society and our economy have become far more complex and problems far more technical than in the late 18th century and indeed when the founders created our nation. Congress set broad principles into statute and leaves it to expert agencies to carry out that statute in conformity with those principles. It's the executive that does administer the law. In short, Congress retains ultimate legislative authority. It can delegate that authority. It can also rescind or limit the scope of that delegation. This process has worked well to millions of Americans from a wide variety of harms, protect millions of Americans from a wide variety of harms, enhance innovation and economic growth, and ensure basic fairness and justice. It was made possible by a broadly written Constitution that's flexible enough to accommodate changing times and circumstances. That was the true wisdom of the Constitution's framers, to create a document at once strong enough to serve as a clear framework of government, but also adaptable so as to be enduring. I look forward to hearing our witnesses' testimony. I yield back the balance.
I thank the gentleman, and now I recognize the chairman of the full committee, Mr. Goodlatte from Virginia, for his opening statement.
Thank you, Mr. Chairman. James Madison wrote in Federalist number 47, "The concentration of executive, legislative, and judicial power in the same hands is the very definition of tyranny." Yet White House Chief of Staff Dennis McDonough recently said, "Audacious executive actions are being crafted to make sure the steps we have taken are ones we can lock down and not be subjected to undoing through Congress or otherwise, beyond even those unconstitutional actions the President has already taken." The founders would have expected members of the House of Representatives, known as the People's House for its most direct connection to the will of the people, to aggressively guard their role in the constitutional legislative process. This task force will do just that in a manner that educates other members and the public on the dangers to current and future generations of the ceding of power away from the people's House and Congress generally. In Federalist Number 57, Madison wrote, "The House of Representatives is so constituted as to support in the members an habitual recollection of their dependence on the people. Before the sentiments impressed on their minds by the mode of their elevation can be effaced by the exercise of power, they will be compelled to anticipate the moment when their power is to cease, when their exercise of it is to be reviewed." Keeping legislative power, and in particular budgeting power, close to the will of the people was considered so important that the Constitution specifically provides that the House of Representatives has the exclusive authority to originate revenue bills. Indeed, regarding budget matters, when the first Congress in 1789 considered the law creating the Treasury Department in the executive branch, the bill, as originally introduced, authorized the Secretary of the Treasury to devise and report plans for the improvement and management of the revenue. But it was feared that even giving the Secretary of the Treasury the modest power to report plans implied too much authority for the executive branch. And so the bill was amended to authorize the Secretary only to prepare plans regarding the management of revenue. The amended bill also specifically required the Secretary to make report and give information to either branch of the legislature in person or in writing, as he may be required, respecting all matters referred to him by the Senate or House of Representatives, or which shall appertain to his office. It thereby allowed Congress to request financial information directly from the Treasury Secretary, bypassing the President, and made clear that Congress and not the President was the ultimate authority on budget issues. But today, as our witnesses will elaborate, Congress exercises far less control over budget matters than was originally intended. Whereas early Congresses specified exactly how much money would be spent for how long, to build a lighthouse or a post road, for example, many federal programs today, enacted by Congresses decades ago, are administered by the executive branch and funded on an autopilot basis, their allocations increasing automatically by statute without the need for any periodic review by Congress. The threat posed by the ceding of legislative power by Congress to this generation and future generations can often seem abstract in the midst of intense policy debates in an historically hyper-partisan environment. As law professor David Bernstein has written, the authors of the Constitution expected that Congress as a whole would be motivated to preserve its authority against presidential encroachment. The founders, however, did not anticipate the development of our two-party system. At any given time, around half the members of Congress belong to the same party as the president and do not want to limit their president's authority. Yet, as then chairman of the House Judiciary Committee, Democrat John Conyers said under the presidency of Republican George W. Bush, "I believe it is in all of our interests to work together to rein in any excesses of the executive branch, whether it is Democratic, Republican, or even Libertarian hands." I agree with Ranking Member Conyers, and I look forward to hearing from all of our witnesses today.
Thank you, Mr. Chairman. Now recognize the ranking member of the full committee, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman. And I thank the previous speaker for his recollection of our comment at an earlier period. Members of the committee, I've expressed from time to time the hope that we could work collaboratively in some areas of mutual interest, in particular those centering on strengthening Congress's ability to conduct oversight of the executive branch. I'm hopeful that there's room on this task force for bipartisan cooperation as much as possible. That being said, I also recognize that there will inevitably be areas of fundamental philosophical differences between the majority and the minority. On some level, Our hearing topic today on the original understanding of the role of Congress and how far we've drifted from it reflects both potential paths for this task force. To begin with, there are indeed policy areas like war powers matters where Congress has, to me, failed to assert itself sufficiently, leaving room for the president to expand his unilateral authority. As one of our witnesses, Professor Vladeck, will testify in greater detail, the earliest Congresses understood that inaction or indifference by Congress in placing specific limits on a president's war-making authority enables and even invites the expansion of presidential power at Congress's expense. Simply put, if Congress fails to act to place limits on presidential authority, it has little basis to complain about separation of powers concerns. It is also important to remember that when Congress has delimited executive power by statute, there's a difference between cases where a president simply ignores such limits and cases where a president interprets a broad delegation of authority by Congress. A president might simply ignore clear statutory limits that Congress has placed on his power. President George W. Bush, for example, claimed the authority to ignore statutory limitations on his exercise of power with regard to national security, including prohibitions on torture and warrantless surveillance, among other things. In other cases, Congress has given a broad grant of authority to the executive branch for the purpose of implementing statutes, and there may be a dispute as to the precise scope of that grant of authority. It is important not to conflate these situations. The former is far more troubling from a separation of powers perspective than the latter. Finally, we must ask why it is that Congress has chosen in many instances to delegate authority to the executive branch, particularly with respect to economic and health and safety regulation. In large part, this is a reflection of the fact that we live in a society that's far more complex than the one that existed in the late 1700s. As even our witnesses here this morning acknowledge, the country and the Congress were far smaller and simpler at that time. And the framers wisely built in some, quote, flex in the joints, unquote, of our Constitution precisely to capture all the changes to our society and economy that could not be foreseen in the 18th century. It's important to remember that even where Congress has delegated authority to the executive branch, the power to legislate ultimately still resides with Congress. Congress is always free to rescind its delegation of authority or to narrow the scope of delegation. And so I look forward to an engaging discussion with our witnesses and among ourselves. And thank all of you for being here. Thank you, Mr. Chairman.
I thank the dapper gentleman from Michigan for his statement, and without objection, other members' opening statements will be made a part of the record. Let me now introduce our witnesses. Our first witness is Matthew Spaulding. He's Associate Vice President and Dean of Educational Programs, Hillsdale College. Mr. Spaulding also oversees the operations of the Alan P. Kirby Jr. Center for Constitutional Studies and Citizenship here in Washington, D.C. Our next witness is Joseph Postel. He is the Assistant Professor of Political Science at the University of Colorado, Colorado Springs. Professor Postel is currently completing a book titled Bureaucracy in America, the Administrative State and American Constitutionalism. Our third witness is James C. Capretta, Visiting Fellow at the American Enterprise Institute and Senior Fellow at the Ethics and Policy Center. Mr. Capretta has served as an Associate Director at the White House Office of Management and Budget and as a Senior Health Policy and Analyst at the U.S. Senate Budget Committee and at the U.S. House Committee on Ways and Means. Our fourth and final witness is Stephen Valdek, Professor of Law at American University, Washington College of Law, and he's teaching and research focus on federal jurisdiction, constitutional law, and national security law. We welcome you all here today and look forward to your testimony. Each of the witnesses' statements will be entered into the record in its entirety. I ask that each witness summarize his testimony in 5 minutes or less to help you stay within that time. There's a timing light in front of you. The light will switch from green to yellow, indicating you've got 1 minute to conclude your testimony. When it turns red, it indicates that we appreciate it if you have concluded your testimony. Before I recognize the witnesses, it's the tradition of the subcommittee that they be sworn in, so please stand to be sworn in. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Let the record reflect that the witness is answered in the affirmative. I now recognize our first witness, Mr. Spaulding. Mr. Spaulding, for 5 minutes.
Thank you, Mr. Chairman. My thesis is actually quite simple. It was Congress, the intended primary branch of government, by choosing to diminish its constitutional powers, which enabled the rise of the so-called imperial presidency and the temptations of executive overreach of our day. Likewise, Congress has the power to stop the executive from overwhelming American self-government with bureaucratic rule, should it choose to do so. In my testimony, I discussed the rule of law as it informed the American Constitution, culminating in absolute centrality of lawmaking in legislatures, the full implications of which are seen in the American founding itself, especially the consent to the governed. Hence the importance of Article I, which lodges the basic power of government in the legislature and its ability to make laws. Its core powers listed in Article I. Utmost significance, I point to the power of the purse, the Appropriations Clause in Article I, Section 9, a limit most notably on executive action. And Congress, not the executive, has the authority need to carry out additional functions under the necessary and proper clause. The separation of powers is the defining structural mechanism by way that this works, such that the self-interests of each branch make it a check on the others, and they jealously protect their own powers. This changed with the progressives. They posited a sharp distinction between politics and what they call administration. Politics would remain the realm of expressing opinions, but the real decisions, in theory, they argued, in the details of government would be handled by administrators in what they called the administrative state. The founders went to great lengths to preserve consent and limit government through republican institutions and the separation of powers. The progressives held that the barriers erected by the founders had to be removed or circumvented to unify and expand the powers of government. In this new conception, government is administrative and bureaucratic. Government must always evolve and expand, and in theory, it must remain unlimited. We've been moving down this path slowly for some time. The most significant shift, I argue, occurred under the Great Society, when the federal government set about creating programs to manage the whole range of socioeconomic policy. The expansion of activities led to vast new centralizing authority in the federal government and a vast expansion of federal regulatory authority. It also brought with it what we conventionally mean by big government: huge workforces, massive expenditures, extensive debt, and created a new source of conflict between the executive and the legislative. At first, Congress had the upper hand. Congress had been creating the bureaucracy to carry its wishes. But the more Congress gave away its powers in the form of broad regulatory authority, the more bureaucrats effectively became the lawmakers. The rise of the new imperial presidency should be shocking, but no surprise. As Congress has expanded the bureaucracy, creating programs, delegating authority, neglecting budgeting, the executive has attained unprecedented levels of authority. Modern executives can command the bureaucracy to implement new procedures and policies without the cooperation of Congress by abusing executive discretion, by exploiting the vagaries of poorly written laws, and now by willfully neglecting and disregarding laws which indeed are clear. By acting unilaterally without or against the authority of Congress, the executive not only assumes a degree of legislative powers without legislative accountability, but also avoids responsibility for executing the laws legitimately authorized by Congress. Once it has been established that the President can govern without Congress and by extension without the law, it will prove difficult and perhaps impossible to prevent future executives from following the same lawless path. The only way to reverse the trend of a diminishing legislature and the continued expansion of the bureaucratic executive is for Congress to strengthen its constitutional muscles. Congress must reassert its legislative authority and to cease delegating what amounts to power to make laws. If it allows administrators the discretion to create significant rules, Congress should assert its authority to approve or reject those rules. Second, Congress must regain legislative control over today's labyrinthine state, bringing consent and responsibility back through better lawmaking up front and, as a result, better oversight after the fact. The day-to-day back and forth of overseeing the operations of government will do more than anything else to restore legislative control over today's unlimited government. Third, one place where the power of Congress is not entirely lost and where there is an opportunity for gaining leverage over an unchecked executive is Congress's power of the purse, strategically controlling and using the budget process. If Congress does not act to correct the growing tilt towards executive bureaucratic power, the structure of our Republican government will be fundamentally and perhaps permanently altered. Congress needs to think strategically and act as a constitutional institution, and it must begin doing so forcefully, stating its argument, putting down clear markers, and drawing enforceable institutional lines before the inauguration of the next president, whoever that might be, and regardless of their political party. Thank you.
Thank you, Mr. Spalding, and now I'll recognize Mr. Postel for his testimony.
Thank you very much, Mr. Chairman and members of this task force. I'm delighted to be here and appreciate the opportunity to testify. In my written testimony and in my brief remarks this morning, I'm addressing two questions. The first, how the early Congresses avoided delegating its legislative power over to the executive, and second, how Congress structured itself in its early decades in order to ensure that it, and not the executive, set the legislative agenda. Today, Congress routinely delegates massive legislative lawmaking power over to administrative agencies. This is contrary to the text of the Constitution, and it is contrary to the intentions of the framers. Some scholars claim that early Congresses delegated power to the executive, and therefore it's perfectly okay for Congress doing so today. The historical record, however, shows otherwise. Article 1 of the Constitution states plainly, all legislative powers herein granted shall be vested in a Congress of the United States. It does not give Congress the option in Article 1 to delegate those powers. It sets up, in other words, a non-delegation principle. Early Congresses observed this principle very carefully. The laws they passed were highly detailed. They limited the discretion of the executive. Congress wrote every detail of the tariff laws in its first decades, specifying not only the amounts of the taxation, but the products to be taxed. Congress wrote in very specific detail the routes of the post roads in the early decades of the Republic. In the second Congress, James Madison, a member of the House, said this, we must distinguish, quote, between the deliberative functions of the House and the ministerial functions of the executive powers, end of quote. Legislative determinations, he insisted, must remain in Congress's hands. Ministerial execution of law is the job of the executive. But this leads to my second point. Although Congress avoided delegating its legislative powers in the early decades of the Republic, the early Congresses ran into a related problem. The problem was the executive was influencing the legislative process, setting the agenda for Congress rather than letting leaders within the Congress set the agenda. Our first Treasury Secretary, Alexander Hamilton, was, by all accounts, the most important legislative policymaker in the first decade of the Republic. As president, Thomas Jefferson actually wrote bills to be sent over to Congress to be passed. This was not appropriate for a system of separated powers, and Congress knew to reverse this it had to reclaim the authority to set its own agenda. Congress's solution to the problem was to set up internal structures of power to provide the necessary leadership within Congress to allow it to set and implement its own agenda. Without leadership, Congress realized it would succumb to what is called a collective action problem. Without leaders in the Congress, members would cater to their districts back home rather than working together to pass laws in the national interest. Throughout the 19th century, Congress modified its internal procedures and strengthened its leadership in order to provide the solution to these collective action problems. By 1825, the House had set up 28 standing committees to provide it with the expertise needed to free it from the expertise of the executive branch. Later in the 1800s, the Speaker was given significant, even massive authority to set the legislative agenda and influence members to promote that agenda. Most of that authority, centralizing leadership in the Congress, has since been eliminated by progressive reformers. As a result of its internal leadership that it developed over the first century of its existence, Congress's ability to manage its affairs improved dramatically. And not coincidentally, in the 19th century, the power of the executive diminished dramatically. The early experience of the Congress therefore teaches us a second lesson. Without internal leadership, Congress will follow the agenda set by the executive rather than its own. Our Republican form of government is predicated upon a strong legislative branch to serve as the place of popular representation. One person in the White House cannot possibly adequately represent the American people. In seeking to preserve its role, Congress should consult the lessons of its early experience. Members of this task force, thank you very much for the opportunity to present this testimony, and I look forward to your questions.
Thank you, Mr. Postel, for your testimony, and the chair now recognizes Mr. Capretta for his testimony.
Thank you, Mr. Chairman, and members of the task force. I'm very pleased to be here this morning. Thank you for inviting me. The power of the purse is arguably the most important power granted to Congress in the Constitution. It is what separates our system of government from many others. The United States President, unlike a king, cannot decide to withdraw funds from the Treasury without an appropriation by Congress, no matter how pressing the purpose. Even in an emergency, such as in the aftermath of 9/11, presidents must go to Congress and ask for the funding. This power of the purse is the primary means by which the people's elected representatives exert control over the size, direction, and activities of the federal government. Over recent decades, Congress has chosen to steadily dilute this power by granting to the executive branch permanent and oftentimes unlimited or ambiguous appropriations. This granting of permanent spending authority, generally for programs that are called entitlements, has delegated to the executive branch significant discretion over the terms of this spending. Moreover, because the spending authority is open-ended or indefinite in appropriation terms, Congress has given up substantial control over the overall size of government, over total federal spending, and over deficits and debt. The list of programs with spending authority in permanent spending authority in current law is long. It begins, of course, with the major entitlement programs, but there are many other programs with permanent spending authority too, including the Supplemental Nutrition Assistance Program, the Social Services Block Grant, some functions of border security and control, portions of federal housing assistance, reinsurance and risk corridor payments to insurance companies under the Affordable Care Act, and much else. The spending authority provided by Congress for other programs are often flexible enough to accommodate substantial and expensive executive discretion. For instance, the current administration used its authority under the SNAP program to waive the state-enforced work requirements in the program for a number of years. The result has been a surge in enrollment in the program that is well above the historical norm, even after taking into account the soft labor market of recent years. The provision of permanent and open-ended spending authority by Congress has resulted in a complete transformation of the federal budget. 64% of the federal budget was devoted to annually appropriated accounts in 1965. By 2015, that portion of the budget had shrunk to 32%, while spending on mandatory and entitlement programs now takes up more than 3/5 of the entire federal budget. It is not a coincidence that as budgetary pressures have risen, the growth of political pressures have built to cut discretionary appropriations. In recent budget deals, it has been much easier for Congress to apply significant pressure on discretionary accounts than it is to apply pressure on the permanently appropriated accounts, and we can see the result of that in the long-term trend toward lower spending on that portion of the budget. It will not be possible to reverse the trend toward permanent appropriations authority quickly, nor would it be advisable for Congress to undo such authority in every program. I'm not arguing for that. For instance, in Social Security, it is important to have a program with some certainty associated with the provision of retirement benefits. Workers need that to make appropriate financial plans. But making allowances for the legitimate need for program certainty need not mean that Congress must cede all budgetary control to the executive branch. Congress should consider several steps to reverse current trends and bring more spending back under the direct control of the House and Senate. Through the budget resolution, Congress could consider imposing limits on what is spent on the non-discretionary portion of the budget. This would require a change in law before this could be done. Such a limit would need to be enforced with some automatic restraints if it were ever to be breached, and some programs could be accommodated with exemptions or adjustments. But the basic idea being putting an overall limit would restore Congress's ability to budget in this area of the budget that it is not controlling today. Further, Congress could also begin to reassert its role by imposing specific limits on certain programs. For instance, Congress could specify that a program's permanent appropriation may not grow by more than some rule, such as the rate of inflation. If a program were to projected to grow faster than that, then the executive branch would be required to come back to the Congress and ask for additional spending authority, perhaps then triggering some reforms. The U.S. Constitution gives Congress the sole power to appropriate funds out of the Treasury. Over many years, for understandable reasons, Congress has delegated a lot of that authority now to the executive branch. It's time to begin reversing that trend. Thank you.
Thank you for your testimony, Mr. Capretta, and now I recognize Mr. Vladek for his testimony.
Great. Thank you, Chairman King, Ranking Member Cohen, distinguished members of the task force. Although many have been quick to blame the president for the perceived drift in the separation of powers, I want to suggest in my brief remarks today that any such drift is at least as much a result of legislative torpor, an unwillingness on the part of Congress to use substantive legislation to better define and police the authority delegated to the executive branch. When discussing concerns over executive power, the founders would have distinguished, and did distinguish, as I explained in more detail in my written statement, between three types of interbranch disputes. The first type of interbranch dispute, and by far the least significant from a separation of powers standpoint, arises from disagreement between Congress and the executive branch over the terms of a statute that the executive branch is enforcing. In such cases, the issue is not whether the president is acting unconstitutionally, but rather whether the actions of executive branch officials are consistent or not with whatever directives Congress has prescribed. Moreover, the Supreme Court has typically afforded deference to the executive branch's reasonable interpretations of ambiguities in the statutes it is tasked with enforcing, even if the courts or the current Congress might read the same text differently. The second type of interbranch dispute involves cases in which the executive branch claims a constitutional authority to act in the face of congressional silence. As Justice Jackson explained in his celebrated concurring opinion in the Steele seizure case, in such circumstances where no statute either authorizes or specifically limits the president's authority, quote, congressional inertia, indifference, or quiescence may sometimes, at least as a practical matter, enable, if not invite, measures on independent presidential responsibility, unquote. The third type of dispute, which poses the gravest threat to the separation of powers, involves circumstances in which the president claims the authority to act in defiance of statutory limits on his authority because, in his view, such statutes unconstitutionally infringe upon his constitutional powers. As Justice Jackson put it in the Steele seizure case, quote, presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution. For what is at stake is the equilibrium established by our constitutional system, unquote. I offer this taxonomy to underscore 3 points that I believe are central to today's hearing and to the broader work of this task force. First, in my view, most of the areas in which President Obama has been criticized for overreaching fall into the first of these categories, and therefore reduced to good faith disputes over statutory interpretation and not over the scope of the president's constitutional powers. As a case in point, consider the current debate over the president's legal authority to use military force against ISIL. The Obama administration has maintained since September of 2014 that apart from isolated and limited acts of self-defense, its general authority to use such force derives not from Article 2 of the Constitution, but from the AUMF, even though that statute, 1, says nothing at all about ISIL, and 2, only authorizes force against groups that were responsible for or assisted in the attacks of 9/11, which occurred before ISIL even existed. Some agree with the Obama administration's legal reasoning, others don't. But even if the executive branch is incorrect in its interpretation of the AUMF, all that would mean is that the executive branch is mistaken in its reading of a statute, not that it is willfully abusing its inherent constitutional authority. This is exactly why many, including President Obama himself, have repeatedly called upon this Congress to pass a new AUMF for ISIL, not because they are convinced that the executive branch is acting unlawfully in using force under the 2001 AUMF, but because such a statute would reassert Congress's institutional role in war making and would set the parameters for the current armed conflict, whether or not the president already has statutory authority for the actions he's undertaking. Second, President Obama has not been nearly as aggressive in claiming the kind of indefeasible executive power that was routinely invoked during the Bush administration, the authority to ignore statutes that, among other things, prohibited torture, limited the government's power to conduct warrantless surveillance, required statutory authorization for the detention of U.S. citizens as enemy combatants, and so on. A common refrain during the Bush administration was that statutes Congress enacted to limit the president's power were unconstitutional. We've heard far, far less of that argument from the White House over the past 7 years, and in my view, for good reason. Third, and perhaps most importantly, unlike with respect to claims of indefeasible power, concerns that the president is overreaching in either of the first two categories I've described can easily be ameliorated through new legislation clarifying the scope of an existing delegation or circumscribing the president's power to act in the absence of statutory authority. In Federalist 51, James Madison famously explained that for our system of separated powers to function, ambition must be made to counteract ambition. I couldn't agree more. But to date, the 114th Congress has enacted 126 public laws, fewer than half the total of what was previously the most unproductive Congress in American history, the 112th, which passed 283. By contrast, the 80th Congress, which President Truman famously derided as the do-nothing Congress, enacted 906 public laws. Reasonable minds can and will surely disagree about the merits of President Obama's policy ambitions and statutory interpretations in these areas and others. What cannot be gainsaid is that this Congress has been uniquely reluctant to counteract or otherwise mitigate those ambitions through substantive legislation. What this underscores, in my view, is that any contemporary drift from the historical balance between the branches has been at least as much a result of congressional inability or unwillingness to do the hard work of legislation as it has been the result of presidential aggressiveness, and has a ready-made solution not in hearings like this one, but in new substantive legislation that would more directly vindicate Congress's institutional and constitutional role. Thank you for your time, and I look forward to your questions.
Thank you for your testimony, Mr. Vladeck. I thank all the witnesses for your testimony. We'll now proceed under the 5-minute rule with questions, and I will begin and direct my first question to Mr. Spalding. Mr. Spalding, I noticed in your testimony that you referenced the 1688 Glorious Revolution and the establishment of a legislative supremacy over the monarch. Could you elaborate on that, if that is the foundation by which our founding fathers looked to when they wrote Article 1 in the Constitution?
Thank you for the question. The importance of the Glorious Revolution to the American Revolution is high. The long establishment of the rule of law through British Constitution culminates in the Glorious Revolution, which could only go so far. It established legislative supremacy. Having said that, that legislative supremacy used by Parliament against the Americans of the colonies was objectionable to them. The American founders perfected this question by constructing a constitution of 3 co-equal branch, the legislative being first, but with the powers we've talked about and the various checks on it, and the executive and the judiciary through the separation of powers system.
So in other words, that was what the founding fathers, one of the things they looked at when they said they need to have a method to restrain an over-exuberant legislative branch that might have been all-powerful. It helped them bring that to the balance of the 3 branches of government.
And they did so by having a written constitution, which was the main difference between the Glorious Revolution and the American Revolution.
Indeed, and thank you. And then, so I also wanted to pose another question to you, Mr. Spalding, and that is that, do you believe that our founding fathers imagined that there would be an executive that would threaten to veto any legislation that didn't include all of his appropriations that he demanded in it, and in vetoing that legislation would bring about a government shutdown? What did you imagine our founding fathers thought would happen if an executive took that kind of a step, which we've seen in the last couple of years frequently?
Well, the first thing to point out is the history of executive vetoes were to be used rarely, only if there were serious objections, mostly having to do with constitutional disagreements with Congress. The president has the right to choose however he wants to veto, but the idea of using a constitutional power like the veto as a way to essentially leverage Congress to pass full budgets, I don't think they probably could have imagined that. But the main thing they could not have imagined is the massive shifting of a power within the separation of powers to the executive branch. The fact is that forces the Congress, in addition to its inability to pass its appropriations bills, into massive omnibus bills at the last moment, which in turn give the executive massive amounts of authority to threaten the veto.
Thank you, Mr. Spalding. I'd like to turn then to Mr. Postel, and your testimony included Your testimony included Article 1 as not set up, you called it a non-delegation principle in Article 1. So take this non-delegation principle to its extreme for us. Does that mean clawing back a lot of the things that are in the executive branch? Does that mean clawing back the rulemaking authority? Does that mean reaching into the EPA and bringing the operations out of there, with the exception of the enforcement and field operations, into the control of Congress? How do you envision this at its, say, taking it to the logical extreme?
Yeah, I think that it largely entails some of the things you're describing, which means not the abolition of any of these programs, not the abolition of any of these regulations, not the abolition of any of these agencies, but rather transferring certain authorities that have been given to those agencies back into the legislative branch. So, for instance, Congress set up multiple departments and multiple agencies from the very beginning, but those agencies and those departments were executive or administrative, which meant they had powers such as investigation, prosecution, and enforcement, but they weren't law-making entities because that was fundamentally the job of Congress. So the rules that bind conduct have to be made by the legislative branch, otherwise we're not in a representative democracy anymore.
Could a Congress then establish enforcement forces to carry out such actions?
I think so, yes.
That would be my conclusion from listening to this. I wanted to take it to that level because this committee, this task force, I believe, wants to look at the full breadth of this so that we can come at what is a reasoned judgment of the people, and we want to restore the power to the people in the end. So I just quickly, Mr. Capretta, the tools that Congress has to enforce today against an executive branch, how long is that list and what are they?
The tools to restrain executive spending authority, you mean?
To restrain an executive branch, an over-exuberant executive branch that might be operating outside the Constitution.
Well, I think the budgetary powers should be restrained. So I would look at the list of programs that have permanent spending authority now, and some of that has been done by Congress. That has been done by Congress, so I wouldn't put it necessarily in a constitutional question. But many statutes have delegated this spending authority to the Congress. I think it's just become a pattern and a practice over many, many years. And it was done originally for programs that had a benefit associated with it, and people wanted some certainty, but it's gone well beyond that to a lot of discretionary programs that are now getting mandatory funding, including agencies of government. I would target those first.
Thank you, Mr. Capretta. My time has expired, and now recognize the gentleman from Tennessee.
Thank you, Mr. Chair. Mr. Spalding, you responded to the chairman's question about the how you thought the founding fathers would have looked at a president who vetoed a bill because he didn't agree with all the appropriations. So you can kind of go back and envision what the founding fathers were thinking, I guess. What do you think the founding fathers, who had a 3/5 clause for slaves in it, would have thought about an African-American president, women voting, or blacks and whites eating together?
I think you're correct in questioning the ability to envision what the founders thought. I think you're absolutely right with that. We constructed it as best we can. I think the point of the 3/5 clause, given that was introduced by abolitionists at the convention, was a move against slavery, was their intention, and that's what Frederick Douglass thought. So I think the intention on that one is actually pretty clear. I think your point you're getting at, however, is correct, which is that meanings of these things do change, and the Constitution and the intentions of the founders should not be so rigid as they don't allow those changes. But my point is that that's where Congress especially comes in. Congress has the necessary and appropriate clause. Congress has those implied powers to make those adjustments. And it's within the legislative branch where those things are best solved, not, in my opinion, by an executive who is unitary or a judiciary, which makes binary decisions. That's what lawmaking means.
Not to get off on a tangent, but yeah, the abolitionists were for 3/5 so that they wouldn't get full population.
The South wanted 1 for 1, which
exactly.
means they would themselves get more representation in Congress,
but
and the abolitionists would object to that.
But both sides took as a given that slavery was something that was appropriate, proper, and not to be challenged in the
That's like,
Constitution.
if you read the transcripts of the convention, including Madison's writings in the Federalist Papers, there was lots of objections to slavery in the constitutions, and the
But it
compromise.
lost. The compromise, the Constitution didn't outlaw slavery.
It made compromise with the institution, but set it on its road to ultimate extinction, which was Lincoln's position. It was a compromise in principle that was, Frederick Douglass argues, not pro-slavery. So on that one, I think the historical record is clear.
You in your testimony described the 60s and 70s as an era which gave birth to big government because during that time the federal government assumed responsibility of the well-being of every American. Can you tell me what you believe the framers would have thought? You've told us what you thought about maybe slavery, but what have they thought about civil rights legislation that prohibits racial discrimination and public accommodations? And do you think civil rights laws, legislation of this nature, which the Supreme Court has upheld as a constant exercise of congressional powers under the Commerce Clause, comport with what you can contend the framers' views were of limited government?
I think the crucial point here, again, is that in the 1960s and 70s, you did see a ramping up and change in the nature of what government was actually doing as a practical matter. The content of those things, civil rights, environmental law, education, I'm not here to debate. I think the federal government's being involvement in civil rights is a monumentally important move in American government. And in American society that would have been agreeable to the American founders on the same grounds that I answered my previous question. But that did change the operational nature of our government, and it changed it such that it introduced a new form of governing, which the progressives call the administrative state, which we're trying to grapple with today. And that changed the nature between the legislative and the executive competition, such that I think today we have an executive with having been delegated a lot of power by Congress, and a large apparatus underneath that executive, whether they're Republican or Democrat, has a lot of leeway to do things with or without specific congressional legislative authority, using discretion, looking at poorly written laws, and now seemingly to get away with the ability to directly act against something that was clearly stated in law.
The simple fact that we refer to the founders of our country as they were as the founding fathers negates over half of the population because they could have been founding mothers. But the fathers put the mothers in a second-rate class, just as they did black individuals, just as they did people who couldn't afford to pay property tax, didn't own property. The fact is the Constitution, which has gone on for many years and is a great document, was not written by infallible human beings. It was written by people, white, male property owners, who were the elite, who wanted a society that protected their interests and did it well. This country has changed much, and Jefferson even wrote about constitutions shouldn't be seen as never changing, that there shouldn't be like a child in clothes that the child then grows out of. He needs new clothes. You need to change as the times change. The process of amending the Constitution is very burdensome, and sometimes the legislature, to see that the society which has evolved is properly taken care of, has to give and delegate to the executive authority to carry out laws when the Congress isn't here, and for the larger government that exists with the difficulties that expire today. I yield back my time.
Thanks, gentleman from Tennessee, and recognize the chairman of the full committee from Virginia, Mr. Goodlatte.
Thank you very much, Mr. Chairman. Mr. Spalding, the issue isn't whether or not the Constitution shouldn't be changed over time. The issue is who changes it and how it's done. Isn't that right?
That's correct. And to go back to this point, the founders weren't infallible, but they created a framework we call the Constitution and its structure, which has served us well to this day. It is precisely the responsibility of Congress as the legislative branch closest to consent
And
to
Congress
make
by-
those adjustments.
Right, and Congress, by 2/3 votes in the House and the Senate, passed the 13th Amendment, which ended slavery, and Congress, by 2/3 votes in the House and the Senate, and by the way, then going to the states for ratification by 3/4 of the state legislatures in each case, extended the right of citizenship to people who had previously been slaves, and Congress, by virtue of the 19th Amendment, extended the right to vote to women. all of which properly should have been done. We would probably agree with the gentleman from Tennessee that these took too long to occur. They were wrong in the first place, but the Constitution itself was created with a device to make those changes. Does the Constitution give the President of the United States the authority to make those changes without the consent of the people through their elected representatives, or without seeking to have the Constitution changed?
No, absolutely not, nor does it give that power to the judiciary. Those two institutions, especially executive, are there for particular purposes to act in light of legislative action through the lawmaking process. That's why precisely Congress is the first branch, and it's the primary branch as intended by the founders.
Is there anything in Professor Vladek's testimony that you'd like to respond to?
Well, I think it's interesting the extent to which there's actually a lot of agreement here in a certain way, the difference being that he thinks it's a good thing, whereas I would probably think it's a bad thing. When the executive does not have authority, he's not free to act as he chooses. There is a lot of ambiguity in laws, how they're written. There are interpretive debates. But short of that, the executive can't do whatever they want. I would strongly encourage this task force to actually flesh out his three types of distinctions between of executive actions and focusing on those that are the most problematic. And here I'm in agreement with him.
And point of fact, we're always going to have differences of interpretation of laws and even of the Constitution itself between the executive branch, the legislative branch, and the judicial branch. But what we're about here is recognizing that over time, for a variety of reasons, the growth of the size of the federal bureaucracy, the transfer of power by the Congress to that bureaucracy by passing laws that contain with them massive regulations, and other actions taken by the Congress's powers are diminished. The Congress is the body of the three most close to the people, because all of us are directly elected by the people. In the House, very sensitive, because every 2 years we're up for re-election. Only 2 people in the entire multi-million person executive branch are elected by the people, the president and the vice president, and no one on the United States Supreme Court is directly elected by the people. So the issue before this task force is to determine how best to restore those powers to the United States Congress. Not whether there aren't going to be differences of opinion. Sure they are, but what ways can the Congress assert itself to make sure that when it recognizes that it passed laws that are being misinterpreted by a president, that they are able to restore their authority?
That's why looking at this process we refer to as the separation of powers is so crucially important. Not as a legal technical matter on this or that specific thing, but as a general matter. This body should act as a constitutional institution in reclaiming those powers. And that should be true whether it's a Democratic Congress or a Republican Congress, and a Democratic president or a Republican president. If you don't have that back and forth, you have no check. And if you have no check, you have nothing to prevent the executive or the judiciary from doing as they wish and going forward.
Let me briefly go to Mr. Postel and Mr. Capretta and ask you, what do you think are the best reforms for us to consider that would restore the role of Congress as originally understood?
Well, I think, as I tried to suggest in my written and oral testimony, that Congress needs more leadership from within the Congress in order to ensure that it's not following leadership outside of the Congress. So,
Mr. Capretta?
I would get a list, pardon me, I'd get a list of all the programs that have now gotten permanent spending authority, and especially the outside the major entitlements, which I don't think will be changed, and look at those that have some spending authority that doesn't require them to come back to the Congress on a regular basis, and review those to see if they're appropriately getting that funding or not, and change the statute and require many of those programs to get annual funding from the Congress.
Thank you very much. Thank you, Mr. Chairman.
Gentleman returns his time, and the chair will now recognize the ranking member of the full committee from Michigan, Mr. Conyers.
Thank you, Mr. Chairman. Let me ask Professor Vladek to respond to some of the responses that we've heard from your fellow witnesses.
Sure. I mean, I guess I just have 2 brief points. The first is, I mean, I think you've heard a lot of consensus that the best solution is legislation. right? That the best solution to Congress reclaiming its institutional role is for Congress to legislate more often and more aggressively. And with regard to Chairman King's point about the veto, it's worth stressing that President Obama to date has vetoed 9 bills in his tenure. If that keeps up, that'll be the fewest by a 2-term president since James Monroe. So it's not exactly like this is a president who has been over-aggressive in wielding the veto pen, whether or not we might agree or disagree about the terms and the reasons for vetoing. Briefly, on the founding era sort of understanding of delegation, I think it's a bit of an overstatement to suggest that Congress never delegated power to the president in the early years. One of the areas of my expertise is the use of the military. And if you look at the early statutes regarding the use of the military in domestic emergencies, they were full of delegations to the president to decide for himself when an emergency had arisen, to decide how best to respond to the emergency, to figure out which forces to use. And let me suggest to the task force, this was for a good reason. At the founding, Congress was out of session for most of the year, right? Congress was a part-time concern. And so when, as in the case of the Whiskey Rebellion, you had domestic disturbances that arose when Congress was out of session, there had to be delegations of authority to the president, lest he be unable to respond and to protect the public order. So, Mr. Conyers, I think my basic response is that I think there's a lot of common cause among the panelists, that the real solution here is legislation. We might disagree about which legislation we would put first. For example, I might prioritize an AUMF for ISIL over some of the other bills that my fellow witnesses might prioritize. But I don't think the history is clearly as against the current constitutional structure as some of the questions have suggested.
Let me just ask, in your written testimony, you discussed the difference between defeasible and indefeasible executive power. Now, why, in your view, is a separation of powers violation based on a misuse of defeasible power less pernicious than an inappropriate claim of indefeasible power by the executive branch?
Sure. I mean, I think the basic answer for that is, again, the role of Congress. If the president is asserting defeasible power in a way that Congress disputes, Congress can pass legislation to rein it in, and the president's own theory would require that he defer to the statute. Indefeasible power, in contrast, is the president claiming the authority to not be bound by a statute. In that case, nothing Congress does can move the ball. The only thing that can happen is the courts could strike it down. And I think this is what we saw, for example, in the early Supreme Court case I referenced in my testimony, Little versus Bareem, where Chief Justice Marshall went out of his way to say that the reason why a particular naval capture during the quasi-war with France was unlawful was because Congress had legislated. Had Congress not legislated, the president might have had more power. So that's why I think there's a lot more concern in an indefeasible case, because in that context, the president is effectively disabling Congress from acting, as opposed to just waiting for Congress to act.
Do any of your 3 fellow witnesses want to add to the comments that were made by Professor Vladeck? Both of you, okay.
Again, I'm struck by the amount of agreement, but also we should see the striking disagreement here. The claim is not made that Congress cannot, under any circumstances, delegate authority. The question is what amounts that authority and under what circumstances. There are clearly differences. But I think the point is that at some point, which I assert occurs sometime in the 60s and 70s, we have crossed a Rubicon such that the amount of delegation across the board in different areas, now with different agencies, giving them their own ability to raise their own money, has effectively created a circumstance where the lawmaking power has been delegated over to those in a way that I find objectionable, both in terms of its violation of separation of powers and broadly its violation of the Constitution.
Yes, Professor Vladeck has suggested that the historical record is not as conclusive as I suggest in my testimony. He notes the existence of legislation early in American history where Congress said, when such and such an event occurs, X will happen, and the president gets to decide whether the event has occurred. That's what we call contingent legislation. All legislation is contingent legislation. That's not a delegation of legislative power. It's a delegation to say, when X happens, then the law is triggered and the executive gets to act. So I wouldn't point to those examples as illustrations of legislative delegations of legislative power.
Could I ask if Professor Vladeck has any closing comment?
Well, I mean, I dispute the notion that everything changed in the 1960s. The first major administrative agency was created by Congress in 1887. That's the Interstate Commerce Commission. The federal government gets massively more expansive during the Second World War. The modern administrative state is first upheld by the Supreme Court in 1932. So, I don't think we can look to the 60s as the moment where things went off the rails. If we really think that Congress has abdicated its constitutional responsibility by giving all this power to the administrative state, that's perfectly fine. But if that happened, it happened in 1887 and has been going ever since.
I thank the chairman.
The gentleman yield back his balance of his time. The chair would now recognize the gentleman from California, Mr. Issa.
Thank you, Mr. Chairman. I think I agree with Professor Vladeck. 1887 probably is when the founding fathers were gone and forgotten, and weak a Congress deciding that it was a lot of work and summers were hot here, decided that, well, what the heck, let them do it. We've still got the power of the purse. Since before I came to Congress, I think all but two people on the dais probably, people still thought they could shut down the government by not funding and everything would be taken care of because, of course, the executive would capitulate. We know that not to be true. It's the most impotent power we have, apparently, is the power of the purse, proven by the impotency of those who shut down the government and then panic when, what a surprise, the government shuts down. I'm going to take a little different tact. And, Mr. Chairman, I ask unanimous consent that a sample of the 17 letters I sent on December 13, 2012 be placed in the record. This particular one is addressed to Attorney General Eric Holder.
Without objection, so ordered.
Thank you. During a different period of my service, my job was oversight. And overreach, mismanagement, abuse of power is the primary jurisdiction of Congress through oversight to determine. Now, this particular letter I'll use, and I'm going to ask each of you a couple of questions related to it. This one happens to make a point that there is a rampant problem within the government, that government officials at high and not so high level are failing to comply with the Federal Records Act and circumventing the requirement that their emails and other communications be kept under the Federal Records Act. Now, that includes Secretary Hillary Clinton, we now know, at an abusive level. She simply had none and left the government with 100% of those documents. It included one of the key figures in Solyndra, a fellow named Jonathan Silver, who wrote, and this was included in the letter to the Attorney General, as an example of something we should be careful about. In his email, he said, don't ever send an email on DOE email with a personal email address. That makes it subpoenable. In fact, a person who has never been punished went out of his way to advise others how to circumvent the oversight of Congress by eliminating the very existence of the documents that would be necessary. Now, December 13, 2012 is interesting only in that I asked 17 cabinet-level officers about the private use of email. One of them was Secretary Clinton, who, of course, did not answer, and her successor, Secretary Kerry, answered erroneously, not admitting that obviously his predecessor had used it widely and left with all of them. Oddly enough, Eric Holder also didn't respond during his tenure and later responded essentially in the negative. And we now know that Eric Holder actually emailed from his personal email, was aware of the personal emails, but in his case, another part of this was I asked if you were using any pseudonyms, because that also had been a tendency over at EPA, and he did not mention that he used Kareem Abdul-Jabbar's true name as his false email.
Damned if I know.
Damned if I know. There you go. Thank you, John. So, my question to each of you, and I'm going to get to Professor too, is since the Congress appears not to have the tools to hold them accountable, isn't the most important thing we do to build the tools to hold these executive branch officials accountable, up to and including the ability to get a quick redressed in the courts. And I'll close with this, and then I want each of your answers. Brian Terry was murdered in Arizona in 2010. In January 2011, this Congress was lied to about Fast and Furious. As of today, we are still in the court and have not even gotten to appeal the judge's ruling to get the documents related to it. Is that acceptable? And shouldn't this committee's primary remedy for this to get an expedited ability to get to the courts so that if, in fact, Professor Bladdock is right, and these are just misunderstandings and disagreements, that, in fact, they can be arbitrated fairly? Mr. Spaulding.
Thank you, Mr. Issa. I agree with your overall point about rebuilding the tools. And I also agree with your point about the subpoena power and being able to get a quick decision from the judiciary. I think you're right about that, and so yes, but I would say as a general matter, I don't think Congress's powers of the purse are impotent. I think there's some great possibilities. So I would include, in terms of rebuilding the tools, also rebuilding your day-to-day tools, which is going to give you control over the executive so that you do oversight before in the early writing of legislation. That'll make your oversight later much easier.
Mr. Purcell, quickly, because I did kind of use all the time.
I'll concur with that.
Okay, Mr. Capella.
I would just agree with Matthew on the power of the purse, that done right, you know, if it's just all or nothing, if you try to shut down the entire federal government, of course that becomes a cataclysm. But I think if the Congress starts to reassert its role in limits on individual appropriations across the board and reassert that in the appropriations process, agency by agency, program by program, so that those programs don't have as much discretion and they have to come back to the Congress more regularly, you will get more control.
I'll just say very briefly, I'm a big fan of Judge Bates' 2008 ruling in House Committee of the Judiciary versus Myers. Which
So am I. As a matter of fact, I hope Mr. Conyers is still a fan of that since it was in his favor.
But just to amplify briefly, if I may, I think the reason why that opinion makes so much sense is because at that point, litigation had become the last tool to avoid potentially holding a member of the executive branch in contempt unnecessarily. And so I think there are remedies that can be exhausted within this body before resorting to the courts. I think it's exactly what Judge Bates understood in that ruling.
Mr. Conyers, I know my time has expired, but is that your recollection that you went to court rather than holding someone in contempt? Wasn't it that you held them in contempt and that gave you the ability to go to the court? I just want to make sure we make the record straight, and that was your action.
I believe that is correct.
Thank you. Thank you, Mr.
Could
Chairman.
we hear Mr. Professor Vladek's comment on that? Because he was vigorously shaking his head.
The gentleman's time has expired. However, the chair would recognize the gentleman from New York for his 5 minutes.
But before that, could we hear Professor Vladek's comment on that last thing?
Oh, of course, Mr. Chairman.
All I would say is, if I recall correctly, the posture of that case was a declaratory judgment action by the Judiciary Committee to litigate Ms. Myers' claim of executive privilege in anticipation of whether she could be held in contempt. So she had not yet been held in contempt when the declaratory judgment action was brought.
The gentleman's time has now finally expired, and we recognize the gentleman from New York for his 5 minutes.
Thank you. I appreciate that clarification. Let me ask first Professor or Mr. Capretta. You testify about Congress's permanent appropriations for things like Social Security and Medicare and various other things, and this is a bad thing because we give up our power. Now, my first question was, so in other words, you think we ought to abolish Social Security, Medicare, and Medicaid, but then you said, no, you wouldn't suggest that, but we ought to bring these programs under control by programmatic limits, by additional spending control, et cetera. But what you're saying is, and tell me why I'm wrong in this, is that the only way for Congress to avoid what you see as the evil in these permanent appropriations, as you put them, is to put automatic clauses into effect that would have the effect of cutting Social Security automatically or cutting Medicare automatically unless Congress from time to time stepped in to change that.
Well, I think Congress could have a lot of different ways of going about this. I would start with the list of programs that have mandatory spending authority goes well beyond the big three, which I would put Medicare and Medicaid and Social Security into that category. There are many other programs that have it. For instance, let me give you an example. There's an administrative agency in the Department of Health and Human Services called the Centers for Medicare and Medicaid Innovation.
They administer Medicare.
No, this part of HHS doesn't administer Medicare per se. What they do is run a series of demonstration programs to test new approaches to organizing and paying for medical care under both Medicare and Medicaid. It's a demonstration part of the Medicare program and Medicaid as well. It gets a $10 billion appropriation every 10 years in perpetuity. So every 10 years it's going to get $10 billion automatically from the Treasury and doesn't ever have to come back to the Congress again. It's then allowed
Except in 10 years?
It continues indefinitely on a permanent basis. And then the funding can then be used to test any number of different things, which they can then take nationwide and implement for both Medicare and Medicaid. Really open-ended authority to change drastically how the programs are run. I think it's delegated way too much authority to this one agency.
You don't
So
argue that it's you don't argue that it's unconstitutional. You argue that it's that it's wrong as a matter of policy.
Right, and just for the record, I'm not a professor and I'm not a lawyer, so
Oh,
you know my ability to comment on its constitutional aspects is very, very. You could take it as an amateur,
Okay,
so
thank
I'm
you.
not going to. But I think it's a statutory issue.
Professor Vladeck, we've heard about the impermissible. The basic subject of the hearing seems to be the impermissible delegation of powers by Congress. Does adherence to the separation of powers require that the Congress not delegate rulemaking authority to the executive branch? And obviously, can you think of a Supreme Court jurisprudence, any Supreme Court jurisprudence that supports this, what I would characterize as an extreme view of the Constitution?
I can, but it's 80 years old, right? I mean, so there was for a time a period where the Supreme Court recognized something called the non-delegation doctrine that died in 1937. There was a case a couple of years ago where,
And that was the switch in time that saved 9?
among other many things that happened in 1937, there was a case a couple of years ago where the parties tried to get the Supreme Court to reassert the non-delegation doctrine, and the court politely declined. I think partly because it's very hard to figure out where the line would be if one were to have a judicially enforceable non-delegation doctrine between what Congress may and what Congress may not allow.
Yeah, let me ask Mr. Thank you. Let me ask Mr. Spalding, I think. Do you think that as part of this non-delegation doctrine, for instance, Congress has delegated, and it's been somewhat controversial, we've delegated powers to the EPA, and we've said thou shalt prohibit or regulate toxic chemicals in the air. Do you think it would be practical or the better practice for Congress to say in each case, well, CO2 can be 6 points per million and a nitrous oxide 7 points per million, and when we discover some new chemical that comes out of manufacturing something else that may be poisonous, Congress must act on that. The EPA cannot say that's noxious?
The point I'm making is not that the delegation argument as understood by the courts, which gave up on it back in 1930, is somehow to be revived. I think the court should rethink that. I'm making a more practical argument when it comes to Congress. Congress is a co-equal branch of government. That
Yes, but my question is, are you saying that we've and not just you, but I mean the general political thing here is that a lot of people say Congress has delegated too much power, and they've focused in, for example, on the EPA and on others too. And my question is, would it be practical or right to require Congress, or even if not right, is it mandated by the Constitution, to require Congress to say, okay, every time a manufacturing process introduces a new chemical into the atmosphere, Congress must, it's okay until Congress comes along and says, that chemical cannot be introduced into the atmosphere, or that chemical can be only introduced at 6 parts per trillion. Do we have the expertise, or could we possibly develop the expertise to do that? Or is there something wrong with saying to the EPA, you make such determinations, we're telling you generally keep poisons out of the atmosphere?
I think the Constitution does mandate Congress to keep control of the lawmaking process.
And so your answer is yes.
And the details of which are to be determined by Congress as to how far
So your
to
answer
go.
to me is yes.
If we look at all the places it has done, it's gone way too far.
So your answer to me is yes. Congress would have to say how much, which chemicals and how many parts per trillion are okay in the atmosphere.
No.
Until no, why not? Where would you draw the line?
I think the problem now is that the line is not don't do nothing, you can do everything. The line is somewhere in the middle, and Congress should do a better job at determining that.
Okay, so you think we haven't done a good enough job. Last question. Professor
Gentleman's time
Vladeck,
has
Mr.
expired.
Spalding asserts that there is no doubt that there's something qualitatively different how this president is using and abusing his powers. Do you agree that there's something, with his statement, that there is something different about the current administration's use of rulemaking authority or exercise of executive authority And if so, can you explain what that something is?
The gentleman's time has expired. The witness will be allowed to answer the question briefly.
Thank you.
Thank you, Mr. Chairman. All I would say very briefly is I think if there's a difference, it is only because of the paucity of legislation, which has left the president with, I think, a lot more areas where there's less legislative direction. Otherwise, I don't think it's a difference in degree or kind.
Thank you.
Thanks, the witness. The gentleman's time has expired. The chair would recognize the gentleman from Florida, Mr. DeSantis, for his 5 minutes.
Thank you, Mr. Chairman. I'm listening. I hear some of the witnesses talking about having 3 co-equal branches of government, and as I look at the Constitution and read, the Federalist Papers, it seems to me that we have 3 separate competing branches of government. I don't know that it's right to say that the founders believed they would be equal. I mean, for example, Madison said that the legislative authority would be the predominant branch, and Hamilton said the courts were by far the weakest of the 3 branches. And so, Mr. Spalding, am I wrong to say that we do have, obviously demarcations of legislative, executive, and judicial authority, but they're competing branches, but the founders didn't necessarily think the courts would be equal to the legislative power?
No, I agree with you. I think that's right. The distinction I would make is that when it comes to exercising their constitutional responsibilities, each branch should carry out its constitutional responsibilities according to its work. So the court does it in terms of cases and controversies that come before it. The executive does it in executing the law, and Congress, which is the primary branch of government by intention, must do it by legislating. So in that sense, they have different responsibilities, and they compete on those. But all 3 are taken oath to uphold the Constitution and act according to its dictates.
And so, just looking at how the branches are exercising authority now, in terms of, there's certainly, I don't think anyone could say that they're exercising equal authority. I think that the executive is by far the most powerful, because you have all the executive powers that are in Article 2 of the Constitution, but then you have most of the lawmaking or policy making is done in the executive branch now. Is that accurate?
As a practical matter, I would say that's yes. The Congress has given over many of its
Hey, hey, hey. Hey, hey, hey. Hey, hey. Hey-o. One, two, one, two, one, two. Check, check, check. 1, 2, 3. 1, 2, 3. This is the microphone. 10D pad is on camera 1's audio. Check, 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 check. 1, 2, 1, 2. Check, 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 check. Yes, yes. 1, 2, 1, 2. Ambient is into. Check, check. Ambient, ambient. 1 2 1 2. Camera 3, yes. Oh. Check the frequency. I think one was EF. I don't know. Take a look. Take a look. The House is in recess until 12 p.m. Oh, yeah, the lights aren't on. Ah. Let there be light. One, two, one, two. Do, do, do. Do you want your white or white? I did. And it just happens to be a full committee list map. Do, 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 do. What's that? Uh-oh. Of Scott Peters from California. One. They're not speaking? Still? Sorry. Yes, Scott Peters from California. You have the floor. Scott Peters. Yeah, right? Scott Peterson. Yeah. Some people just are awful. Yeah, that's the guy who killed his wife, his pregnant wife. And also, yeah. Yeah. No, but probably has a couple of profiles. Hmm. Yeah. Some some ladies like that. I don't know. Yeah. Everyone's got to have a hobby, something to get out of bed for, and no. Yeah. Is it working? Oh, on 3. Okay. I don't know if this white matches that white. This looks a little old. Just saying. Microphone check. This is a microphone check. 1, 2, 3, 1, 2, 3. 1, 2, 3. Committee on the Judiciary, full committee. 1, 2, 3. March 1st. March 1st. 1, 2, 1, 2. Check, check. 1, 2, 1, 2. This is a microphone check for transmission, C-SPAN transmission. 1, 2, 3. 1, 2, 3. Check, check. 1, 2. 1, 2, 3. Check, check. 1, 2. Oh. Check. Check. 1, 2, 1, 2. That camera is right in my face. Check, check. 1, 2. Microphone check for C-SPAN. Full committee on the Judiciary. 1, 2, 3. 1, 2, 3. Check, check. 1, 2. Microphone check. This is sounds awfully loud to me, this microphone, but maybe it's just in the room. Could be. Plenty loud in the room, so check, check. 1, 2. No. Check, check. Oh, and this one's really low in the room comparatively, but I I guess that won't use this one. Oh, well, this one's going to be super overpowering in the room, at least. Yeah. Yeah, I will. Check, check, 1, 2, 1, 2, 3. Check, check, microphone check. I'm going to go ahead and check the other microphone just in a second. Here we go. Okay, I'm going to switch over. And this is the one that is incredibly loud in the room. So the problem, I guess, would be is if they went ahead and went way away from it to make it reasonable in the room, and then it was low for you. But I'm not sure. Check, check. Yes. This is the third microphone. It is reasonably loud in the room. It's completely reasonable sounding in the room and hopefully on the okay? And then this is the last microphone, which is also very quiet in the room as far as I can tell. It sounds awfully quiet. So two of them are really loud. They're probably going into on the same level, but the other two in the middle are loud. The two on the outside are quiet. This one, check, check. This is one of the ones that's louder in the room. Check, check, microphone check. 1, 2, okay.
Check 1, 2, 3, 4, 5, 6. Check 1, 2, 3, 4, 5, 6. Huge difference. This one's pretty loud. This one's not as loud. Okay, so it needs to be somewhere south of the button and somewhere north of it. Sure. Otherwise, it's going to be like, is this on? You know, right. Typical.
I actually think that it's pretty clear. I mean, it feels like it is. You're getting that? Oh. How about, okay. Yeah. Okay. And even if I lean back like this, as long as I'm not doing one of these. Yeah. Yeah.
In 1968, that prohibited anyone other than licensed gun dealers to engage in the business of dealing firearms, a loophole that we've been trying to close that Congress has refused to take up. And by the way, as an aside, I'd point out, refused to take up a single piece of gun safety legislation since Newtown, despite the ongoing moments of silence that take place in the House week after week after week when there's another mass shooting. And so Congress refused to act, and the president took executive action to clarify what the private sale of guns are and to help close that loophole. And the president did it failed to act. I don't understand how that has been characterized as overreach when the fundamental issue here, whether it's on immigration or on guns or on protecting our environment, a whole host of other issues, that when Congress, as we've heard over and over and over this morning, has a responsibility to act. Well, when Congress fails to act, and there is a necessity to use and enforce and interpret existing law, and that's what the president does, it strikes me that's exactly what the president ought to do. Unfortunately, I'm out of time. I yield back, Mr. Chairman.
Gentleman's time has expired. The hearing no question. Chair would recognize the gentleman from Texas, Mr. Poe.
Thank the chairman. Thank you, gentlemen, for being here. It's interesting that my friends on the other side like to use the same excuse that I heard as a judge down in Texas. I would have a person come to court charged with theft, and occasionally they would say, well, Judge, everybody steals in Texas. Give me a break. And the defense being, well, other people do it, so let me go. And you know, I'm a little tired of hearing it. George Bush did it, so it's okay for the president to do it. This issue is not about who does it. It's what position violates the Constitution and overreach. And we can go all the way back to Andrew Jackson if you want to. I mean, some historians think that his invasion into Spanish territory of Florida to kill the Seminoles who were raiding my friend Mr. Johnson's now home state of Georgia, that executive action was illegal because the president didn't get authority from Congress. Andrew Jackson also, when Texas was a country, and some say it still is, tomorrow's Texas Independence Day, in case you're wondering, gentlemen, 180 years. Texas is an independent country, took Congress forever to decide whether or not to recognize Texas as a country. Andrew Jackson said, sure, I recognize them. They're an independent country. And there was debate about whether or not that was legal or not. So executive overreach has been debated a long time. And in my opinion, Congress just sits back and lets it happen. All of you have probably memorized the Constitution. And the way I read it, the Article 1, Section 1, the first word is all. All legislative powers are granted shall be vested in Congress of the United States. It does not say all legislative powers are granted and vested in Congress of the United States unless Congress fails to act. Then the president can pass his own legislation. There's no exception clause. It's the word all. Framers, Madison, probably had a good reason for putting the first word in the first article, all legislative power. The question has been, Congress sometimes doesn't use its authority. Does that give the president the authority to say, okay, I'm going to make my own rules? Probably not. I mean, historically, the way I understand the Constitution was written, Article 1 deals with the legislative branch of government because it was supposed to be the most powerful. Then Article 2 deals with the executive branch. And the Article 3 deals with the judiciary, which was really supposed to be the weakest branch of government. I think as a practical matter today in 2016, the judiciary is the strongest branch of government, because they make laws too, and then you got the president and you got the legislative branch, which basically is very weak because we don't do a lot. And we have brought some of this on ourselves because when the lawmaking authority comes around, we decide to make some bureaucracy to enforce that law. Some of those bureaucracies are legislative, some of those are done by the administration. We tell them to go out and make that law happen, and then we criticize the bureaucrats for doing the job that we told them to do because we won't do it. So I say all that to say, is this, do you agree, Mr. Postal, I'll ask you this question, do you agree or not, failure of Congress to act, and failure to act really is an action, failure to deal with gun violence is an action by Congress. They've made their decision. We've made our decision. But is there an exception clause in the Constitution that gives the executive the right to go ahead and go it his way, like Burger King, have it your way because those legislators, those members of Congress, they don't act?
There's nothing in Article 2 of the Constitution that gives the president the power to make law. And that's because of the reasons you've just indicated. Article 1 gives all of the legislative powers to Congress. So any excuse that relies upon Congress's inaction can't be used to justify the granting of a new power or the assuming of a new power by the president. So if Congress doesn't act, there is no law to execute.
Even if the action by the president is a good idea?
Yeah, I think it's important to separate results and policy from process. And a lot of the comments this morning in conversation is centered around if you insist upon this sort of process, you might jeopardize the kinds of results we want. But good process is important in and of itself, especially a process that says we are going to rule ourselves through our own elected representatives in the legislative branch. So regardless of the outcomes we produce, it would be a good idea for us to preserve the principle that our elected representatives make the law.
Thank you, Mr. Chairman. I yield back.
Gentleman yields back, and the chair would now recognize the gentle lady from California, Ms. Chu.
Professor Vladeck, in your testimony, you state that some forms of executive action are appropriate when Congress is silent or vague on the matter. In recent years, has Congress, through its inaction, create an environment that necessitates unilateral executive action? And can you give us examples that stand out in your mind?
Sure. I mean, I think we'll probably disagree among all of us in this room about which are the best cases. But I think the ISIL example that I referenced in my testimony is actually a very powerful one. When Congress enacted the AUMF in 2001, it didn't even know that Al-Qaeda was responsible for the September 11th attacks, and so it left it up to the president to determine who was responsible. This administration is now claiming that that statute enacted on September 14, 2001 somehow covers the use of military force in countries far afield of Afghanistan against groups completely unconnected to Al-Qaeda. And I think that's a very powerful example of where the absence of subsequent legislation has all but invited both this president and his predecessor to actually take this pre-existing statute and run with it in ways that the original drafters of that statute probably would have been very surprised to see.
And under what constitutional authority does the president have to act in cases such as that?
Well, in that case, I mean, I think the problem there is that that's an issue where the president's arguing he has delegated statutory authority. And so my colleagues who think that that authority can't be delegated in the first place have a bit of an easier time because they say, of course, that delegation was impermissible in the first place. I instead am left to say I don't believe that that's a fair reading of the statute. And then it comes down to a disagreement between me and, for example, administration lawyers about what a particular statute means. That's the kind of disagreement that we see all the time. It's one that this body could fix very easily by just passing a new statute.
Now, in instances where Congress perceives that the executive branch has overstepped its authority, what can Congress do to restore the balance of power?
Sure. I mean, as I say in my testimony, I think in most of the cases that we're talking about, new legislation would do most of the work. The only time where I don't think legislation would be effective in scaling back the kinds of presidential excesses that some have criticized is where the president is claiming the authority to defy acts of Congress and to not be bound by acts of Congress. And frankly, we've seen very little of that argument over the past 7 years. So I think in other contexts, in all other circumstances, new legislation could do a lot of the work.
And how would you respond to the critics that argue that the president would simply veto any attempts by Congress to redress executive overreach?
Sure. I mean, I think there are two responses. I think the first is this president hasn't used the veto pen that often. As I mentioned earlier, he's vetoed the fewest bills of a two-term president since James Monroe, so in 200 years. But second, I mean, if there came a point where the president was using his veto powers in a way that wasn't just to achieve partisan policy outcomes, but was actually jeopardizing the institutional role of Congress, it would be my fervent hope that members would cross the aisle and form a supermajority to override the veto. There's a long history in this country of Congress overriding vetoes on areas where it believed the president was acting unconstitutionally.
Now, there are witnesses that argue that by creating permanent appropriations for programs such as Social Security, Medicare, and Medicaid, Congress has ceded too much power to the executive branch. What are the benefits of creating permanent appropriations for certain safety net programs like these?
Sure. I mean, I think there are a number of benefits. I think first and foremost, it provides stability to those programs so that they're not dependent upon the annual budget process in ways that I think other programs are often held up in the balance at the last minute. Second, I think it allows Congress to actually not spend so much time in the nitty-gritty of whether X amount of money should be appropriated for Y medical procedure under Medicare, for example. So I think the time it frees from Congress, the stability it creates for the program, the ability to allow the executive branch to use its expertise to figure out how best to implement these programs, I think are all benefits of such standing appropriations.
Many of our witnesses are arguing that the Constitution precludes Congress from delegating its rulemaking authority to the executive branch to carry out the will of Congress. Is it unconstitutional for Congress to ask obtaining assistance from the other branches to execute Congress's will? If so, what are the examples?
Frankly, I think this is where some of the other witnesses and I differ. I don't think the Constitution includes a non-delegation principle, and I think I'm with the Supreme Court, which hasn't recognized one since 1936. So, I think Congress can't arrogate the power of the other branches. Congress can't commandeer the power of the other branches. But insofar as this is a cooperative enterprise, I do think Congress has a role, a very powerful role, that I think it has just stopped exercising as frequently in involving the other branches, especially the executive branch, in the implementation of federal policy.
And what's the standard that Congress must follow in enlisting the executive branch's assistance?
I mean, the basic rule the Supreme Court has given is as long as there's any intelligible principle to govern the delegation. So as long as there's just some reasoned basis on which the executive branch is exercising the power delegated to it that's somehow related to the underlying statute, is permissible. We can sit around and debate whether there should be a stronger connection, whether there should be a tighter rule. I guess, insofar as our differences are primarily about policy, I don't think that rises to the level of a separation of powers problem.
Thank you. I yield back.
Thank you.
Gentlelady's time has expired. The chair recognizes the gentleman from California, Mr. Peters.
Thank you, Mr. Chairman. I appreciate the hearing and the chance to hear from the witnesses. It's been very illuminating. And what struck me in all the testimony was that there was an agreement that this is really not a task force on executive overreach as much as it is on legislative underreach, because every single one of the witnesses agrees that Congress could, if we decided to, take a hand and correct this imbalance. I heard, legislative torpor, inertia, indifference, quiescence, inability, unwillingness, and delegation. These are all things that Congress is responsible for doing, and we could do. So at the conclusion of this hearing, I'm left with the impression that probably what we should do is get back to work on legislation from the House of Representatives with which the Senate would agree and that the President might sign. We have not taken up the authorization for use of military force. Was a lot of hue and cry about whether President Obama should have the power to take care of this. I'm willing to take that up. The Congress has not been willing to talk about it. We had an immigration reform bill in the Senate in 2013. It got 69 votes. Immigration is one of the areas in which the President's been active and has been criticized for being so active. But we didn't even get a vote on that in the House of Representatives. That was a bipartisan immigration bill. We could have taken that up right here, maybe amended it, but we were prevented from that vote on the House floor. There's a regulatory reform provision that came through the House, has no chance of passing this through the President's signature. I got an idea that we could achieve some of the same objectives with the President's cooperation. Tax reform is something in which actually I agree with many of my Republican colleagues on some of the tax policy issues. Chairman Camp, when he was the chairman of Ways and Means, issued a plan to start working on that. Speaker Boehner killed it the next day and said, we're not going to talk about it. Really what we have here is, as the witnesses suggested, is a failure of Congress, not something to criticize President Obama about. And sometimes I think it's a little bit like me asking myself, why is my hair not combed? It's because I didn't comb it. We have all the power we need to take care of this. Mr. Capretta said on the issues on entitlement spending or social insurance that we should take those statutes and amend them, and that's something we have the power to do. I think Mr. Pastel said what we needed is more leadership within Congress. Well, I'm ready for that, and I think what we could do is probably rather than having hearings about what Congress isn't doing, we should just get about the business of doing congressional work. And with that, I yield back.
The gentleman yields back. This concludes today's hearing. Thanks to all of our witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. I thank the witnesses, and I thank the members and the audience. This hearing is adjourned.